All right, it's time to look into what's trending in employment law. Lawyer, you're on the clock.
So Phil, today through the magic of technology, I'm coming to you kind of live, kind of maybe recorded or not, I don't know. But I want to help the audience out here today and talk about a couple of cases. We've talked about this previously on the show, and that is the topic of what's called Chevron deference. And what this means is that for the last 40 or so years, the United States Supreme Court, after its decision in Chevron versus Natural Resources Defense Council back in 1984, what the court held in that case is that U.S. courts should give substantial deference to federal agency decisions. Okay, and so what that means is that when the federal agencies make an announcement on what the law is or interpret the law, the federal courts are supposed to give substantial deference to that. And so Chevron really presents a two-step framework for courts to interpret statutes like Title VII, the ADA, now the Pregnant Workers Fairness Act, the Pump Act, the ADEA, the Fair Labor Standards Act, the National Labor Relations Act. And so under this two-part test, if the text of the statute directly speaks to the precise question at issue, then an agency and a court must give effect to the unambiguously expressed language of the statute. So in other words, Phil, what that means is that if the statute is clear on its face, the courts and the administrative agencies are supposed to follow the statute. All right?
All right.
The second step is if the court determines that the statute has not directly addressed the precise question at issue, but is instead silent or ambiguous with respect to the specific issue, the court should defer to an administrative agency's interpretation of the statute so long as that interpretation is permissible. Okay? So it seems pretty straightforward. Now, let's take the Fair Labor Standards Act, for example, in the Department of Labor. The Fair Labor Standards Act is silent or ambiguous on, excuse me, much of the detail that relates to wage and hour. And so courts have often had to apply the second step and defer to the wage and hour division's regulations and interpretations. And so specifically here, the text of the Fair Labor Standards Act, the law itself exempts from overtime requirements, quote, any employee employed in a bona fide executive, administrative, or professional capacity. But the Fair Labor Standards Act itself does not provide any further explanation or definition of what those terms mean. It doesn't say what is an executive, what is an administrative, or what is a professional. So the division,
so the agency would determine that.
That's right. So the division of the Wage and Hour Division has issued regulations. They've issued approximately 50 separate regulations and tons of opinion letters. And there's a 75-page chapter in its Field Operations Handbook, among other materials, to interpret and provide guidance on this one provision of the Fair Labor Standards Act. Now, why am I talking about this? Because we know recently, just in the last few weeks, the Wage and Hour Division recently issued a rule to increase the exempt salary threshold of nearly 40 million workers. And so this is an example of a regulation that many believe goes too far. All right. And the significance is that when you have these administrative agencies interpreting what the law is and issuing regulations about the law, and then the courts are supposed to defer to these administrative agencies, what happens in the U.S. every 4 to 8 years? We have a change. Yeah, we have a change in the executive branch of the government, and the executive branch is the entity that appoints people to these administrative agencies. They're then confirmed by Congress. But what happens is with each administration, that pendulum swings wildly from left to right. And so every 4 to 8 years, employers are having to try to figure out what the law is going to be in the area of wage and hour, with respect to the EEO laws, with respect to the National Labor Relations Board, all of those agencies, the NLRB, the EEOC, the Department of Labor, the Federal Trade Commission, the Federal Election Commission, the Department of Justice, all of those are agencies. And so employers, we've talked about it before, Phil, employers on one hand oftentimes don't care what the law is. We just want to know what it is. And we want it to stop changing every 4 to 8 years. And so when the Supreme Court heard oral argument on January 17th in 2 cases that are pending before it, it seems that they're poised to overturn Chevron. And so
That's a big deal.
That is a big deal. And I think that a decision could be coming this month. And, so it'll be really, really interesting to see what happens with the Supreme Court with Chevron deference, especially in the immediate aftermath, if they overturn Chevron. Because I think that'll mean over the long term that this pendulum will stop swinging as wildly every 4 to 8 years. And so
does this mean that instead of going back to the agency for a determination where there is, a debatable difference for whatever the reason, it will go to court?
Well, I think ultimately the courts, they still end up in court anyway. But I think ultimately the courts are going to be following their own legal precedent more than they're going to defer to the agency's standards that change over time. I think that there will be some growing pains if Chevron is overturned, but I think in the long term it will give more stability to employers, which I think is good news. No matter which way the law comes out, I think over time stability is good for employers.
Yeah, I agree. Well, that's I know you've been keeping us up to date since that first happened, which has been several months back. But yeah, let's keep our eye on that. And as soon as we get that information, we'll be sharing it with our listeners. What else do you have, Burt?
All right. So also on Tuesday, the 8th Circuit, which covers Missouri, Iowa, and Minnesota. So that's the circuit that we're in here. They took away a pharmacist's $134,000 jury trial win in her lawsuit in which she accused the city of Sedalia, Missouri, of unlawfully barring her from bringing her service dog to work to help her monitor her diabetes. Basically, the court said she failed to show that she needed the dog to do her job. So this case started when she alleged when the hospital refused to allow her to bring her service dog, Corey, into the non-sterile areas of the pharmacy, and which led to her resignation in September of 2020. The hospital had argued that she failed to show that her request for service dog accommodation was necessary to access the benefits and privileges of employment, and that the verdict was against the weight of the evidence. So basically what the court decided here is that the dog did not actually help her perform her job. The dog was able to sense maybe when she was low on blood sugar, but it did not actually contribute to her providing her job. And so the dog was not a cognizable benefit or privilege of employment, according to the court. And so they said that as a matter of law, this case really should never have gone to trial, and the judge should have granted or directed a verdict in favor of the defendant, the city of Sedalia here.
Wow. Now, is that a common scenario that you'll see where something goes to court and has a jury trial and then after the fact gets overturned by the court?
Interesting question, Phil. Yeah, I would say it's not necessarily common or uncommon. It's just one of those things that happens. I think that here, so juries decide questions of fact, judges decide questions of law, and what the panel said is that this was a question of law, not a question of fact. That the dog did not provide a cognizable benefit to her ability to perform her job.
So what comes to my mind, I think for our listeners, is people are more and more bringing comfort animals, and they might be different than a service animal with them wherever they go. I mean, airplanes and airlines have been dealing with this, and everyone's dealing. You walk through the grocery store where I don't really care to see pets, and there's people walking through the grocery store with their pets, and you're probably smiling because you all do that as the Garland family.
Nope.
I'm guessing. No, okay.
Only to the hardware store.
Only to the hardware store. Yeah, that is a popular one as well.
Yep.
But in the workplace, pets are not normally covered in our handbooks. That's not something that's common to put into the handbook. What should someone do when an employee says, hey, I need to bring my comfort or service animal to work with me starting right now?
Well, there's a very big distinction, Phil, in what you just said there. There's a huge distinction between a service animal and a comfort animal or a therapy animal. So service animals are actually recognized under the ADA, under the Americans with Disabilities Act. And so employers have to allow employees who have service animals to bring them into the workplace under certain circumstances. That's what the case dealt with. It was a service animal, not just a therapy or comfort animal in this case that we just talked about. And you have to go through what's called an individualized analysis to determine if we can accommodate the animal at work. There are only two recognized service animals, and those are dogs. And believe it or not, Phil, miniature horses. Miniature horses qualify as a service animal under the Americans with Disabilities Act.
I thought you might say like miniature pigs or something next. Horses, really? Okay.
Miniature horses, yes. So
what
miniature horses.
What are we coming to?
Well, that's been in the law. That's not an agency interpretation. On the flip side, though, Phil, when you're talking about comfort animals or therapy animals, those are different. And again, under the ADA, it may be appropriate for an employer to allow an individual to bring a comfort animal or a therapy animal to work as a reasonable accommodation. The analysis, however, differs a bit from the analysis where it's an actual service animal. So the point being, to answer your question, is that these are individualized analyses. The EEOC and the courts do not like blanket rules prohibiting either service animals or therapy or comfort animals in the workplace. They want you to go through an individualized analysis.
All right. Well, that's good information, and we'll keep that in mind. And it's never a bad idea if you get confronted with that to have a conversation with Burt or someone here at AIM. We'll be able to help you work through that.
Thank you once again for tuning in to This Week at Work. If you enjoy the show, please share it with your colleagues. Forward our invites. Share the link, aimea.org/thisweekatwork, or follow or subscribe wherever you get your news and entertainment, like LinkedIn, YouTube, Spotify, Apple Podcasts. We're everywhere you are. And you can be part of the show. Send your questions and comments anytime to info@thisweek.work. We'll see you next week, 7:30 a.m. Central Time, when we discuss what's happening this week at work.